Welcome to the Top Texas Lawyers Podcast. This podcast is brought to you by the law firm of Abercrombie and Sanchez, PLLC. You can find us on the internet at astxlegal.com or by calling 1-888-981-7509. Your hosts are Bryan Abercrombie and Samuel Sanchez. Bryan has been practicing law for 18 years and is board certified by the Texas Board of Legal Specialization in the area of family law. Sam has been practicing for 13 years, is licensed in both Texas and Florida, and is a certified mediator. This podcast is for informational purposes only, and all views are the opinion of the hosts. It is not designed to provide legal advice for your particular legal matter, and it should not replace the advice of competent counsel. Welcome, and we hope you enjoy the Top Texas Lawyers Podcast. Hello, good day, and welcome to the Top Texas Lawyers Podcast. I'm your host, Bryan Abercrombie, and with me, as always, is my co-host, Samuel Sanchez. Sam, how you doing?
Not too bad, man. I'm the butter to your bread.
Yes, you are. So, we have our number 5 in our 5-part series on the divorce process, and today we are going to talk about the big red one, the big enchilada, the final nail in the coffin, so to speak, the trial phase of your case.
The money pool, man. Exactly. Yep.
Yes,
trial.
But before we do that, do you have any celebrities you want to talk to us about?
Well, there's a lot of stuff happening in the news. First and foremost, obviously, we know, it's such a turbulent time in the country. There's so much going on. And so obviously our thoughts and prayers go out to all the individuals who out there are putting themselves at risk and harm's way. And we hope that everybody has cooler tendencies prevail, and so that we can kind of move on
the
to
better angels of our
country.
nature, so to speak.
There you go, my friend. But in that, I would tell you that there's a couple of things. Obviously, we're still closely tracking the Cavallari disaster. That's, that epic that continues to go on. Clearly, Jay Cutler has decided that, he needs a break. Last I heard, he was in Montana saying, I want to spend some time with the cows in the mountains. But they are kind of along the process that we're using as a prototype of, this celebrity divorce, this high-profile divorce, this high-asset divorce. They were able to settle the kid issue.
So do you
now
think
that
that
remains for trial purposes.
So do you think, Sam, that the quote of, let me see, where is it? Here it is. We have nothing but love and respect for one another and are deeply grateful for the years shared, memories made, and the children we are so proud of. This is just the situation of two people growing apart. We ask for everyone to respect their privacy, blah, blah, blah.
Well, I'm going to put
they have come to the loving conclusion to get a divorce.
I'm just going to call that bullshit. This is all I'm going to call that. That's just a bunch of bullshit. That's Texas bullshit. Because I would tell you that right now, as it stands, they're clearly communicating through counsel. They're all kind of marshaling their cases in relation to the property portions. Now, it's great that they were able to reach some conclusion as to their children. It's always a good place to be if you can narrow.
Well, did they reach a conclusion, or did they reach a conclusion, or Jay's lawyers just kind of say, you know what, it doesn't look too good for you, pal. We're going to have an uphill climb on this one.
Yeah, I think they were trying to focus their energy on what he feels is going to be most important. I don't think he thinks he's a bad mom. I think he just looks at it and says, we're going to spend most of our time fighting about the money.
Well, and then
let's put our dollars
there. There's the decision that Kristen made not to continue with the show, so we're not going to see, I guess, any kind of drama played out on ETV over the next they're on E, right? On ETV over the next year, yeah. I'm assuming, with the reality cameras rolling. And that makes sense. That's probably a good legal decision for her not to have the cameras rolling during a divorce process.
I agree wholeheartedly. But along those same lines, if you want to take it a step further, something that's currently in the news as well is Derek Chauvin, right? This is the officer who is accused of perpetrating the act against Mr. Floyd that led to his death, right? So his wife immediately went out and filed for divorce. Those are on, she's ready to move forward.
I know we're lawyers and we have to say allegations and alleged, but obviously there's a videotape of the entire incident. So it's not going to be a difficult case for the prosecutor. I guess it's just, how much of the charge, how big of a charge it's going to be.
Yeah, I sure hope not. But you and I have both seen, mammoth cases, mammoth trials go through, It revolving around police brutality, police activity. And we know that, you know what, a trial's a fist fight. And you just never know what the heck is going to come out of that. So,
yeah, that's
which
true.
leads us into our topic for today, trial.
Yes. And this is obviously not a criminal trial, but I mean, let's talk about the custody trial and let's talk about the property trial. And they're all in a custody case. They're all rolled into one. So typically a lot of judges will have you bifurcate the trial and talk about property at one part and custody at another part. And so typically they try to bifurcate the issues. There is, sometimes a little bit of overlap. I don't know that there's a lot, just in the overlap from the standpoint of maybe property division, depending on who's going to have to care for the children and what those costs are going to look like, stuff like that. But when you're approaching the trial, you're going to want to have counsel that are going to leave no stone unturned. And, it's the day to fire every arrow you got in the quiver. You got to fire every shot in the gun, and you got to use all the ammunition you got.
Yeah, everything should be locked and loaded by this point, and it really does take a very in-depth, deep conversation, strategy sessions with your attorney to be prepared for that day. Because, we've spent time talking about temporary orders hearings. We've spent time talking about discovery and subpoenas and depositions and all the things that you're going to gather information. Well, all that should be structured, categorized, prepared, ready for exhibit purposes by the time you get ready to enter into that courtroom. And like you and I both know, the trial is about telling stories, and the better storyteller is the person who's going to win that trial. I mean, all the facts in the world, you can walk into a room overconfident thinking, well, all the facts support me, but somebody tells a better story, and people will overlook facts, even judges at times, to get to a ruling that they feel is, just and right.
Then let's talk a little bit about, the jury trial. I mean, Texas is a place where they have a jury trial, and you think bench trials are tough. A jury trial, you got 12 people who didn't want to be on the jury anyway, most likely. Some people do, don't get me wrong, but for the most part, you have 12 people that don't want to be there. They're taking the day off of work, or several days to have a jury trial. And, the median income in most of these bigger counties in Texas is surprisingly lower than you might suspect. I mean, you're talking 35,000 a year and maybe even less than that. In say Dallas County or Harris County. So your jury pool is coming from a wide swath of socioeconomic backgrounds, and you never know what you're going to get in that pool of 12. And so juries can't decide property matters, but they can decide fault and they can decide custody.
Obviously, that's different in Florida. Florida doesn't afford anybody the opportunity to go to a jury trial on a matter like that. But I would tell you, look, when you're preparing for these conversations, as you're having these strategy sessions with your attorney, you better freaking know what the hell you're talking about. And he or she better know what it's like to be in that room, to walk into the box, to call a jury, to talk to a judge, to prepare these motions in advance. And as a client, you really have to understand your position. And if you can narrow it, to your point, you want to try to narrow things before you walk into the courtroom, if at all possible. Because, Bryan, you and I both know, it would be great if trials went on like they do on TV. You get months and months and months and months to try something, to tell a story, to bury facts, to bring up facts. But that's just not the real world. That's not
the real life. Not a chance in hell. What you get is if you need a full day, if you need a full day, you get 3 hours. If you need half a day, you get 1 hour. If you need a week, you get 2 days. That's the way trial works. So you have to be efficient with your time, and you have to tell a good story to the court, that shows your evidence in a very credible way. And now I think we could probably spend a whole podcast just talking about the jury trial alone, but let's not waste the time with that. I mean, most people are going to have bench trials in a divorce case. So let's focus our efforts on the bench trial. And like I said, a lot of times the trial is going to be bifurcated. I mean, if your counsel is smart, they're going to ask for the trial to be somewhat bifurcated into the property issues and the custody issues. So,
yeah, I mean, absolutely. I think that it's always a wise decision to do that, but there are going to be instances where you're going to want to talk that over with your counsel, because if you look at it and you say, the property issues are absolutely intimately wrapped around children issues. If you have children with special needs and you're talking about, a residence or potential set aside of assets based on their care, or somebody in the relationship has special needs that you're going to be talking about, that may be something.
Let's talk about talk about the custody. Let's talk about the custody side. I mean, if you're talking about a custody case, you have everything from a he said, she said, and I call them I love you witnesses, but you call all all your buddies and all your, all the people you let love you, your family and everything like that to say good things about you. And then the opposing party will do the same thing. He or she will call all their I love you witnesses, and then the judge has a decision to make. But in a lot of custody cases, there's some kind of either an amicus attorney or a custody evaluator that's taking a look at this stuff. Let's talk a little bit about the custody evaluator.
Yeah, look, I mean, by this point, if they prepared a report, you and your attorney are gonna have drilled down into that report. You're gonna have an opportunity, if you need to attack that report collaterally in advance of trial and then during trial, meaning that you have to know everything that's in it, the mechanics of the report, what that reporter actually prepared in their report. Did they do their due diligence? Did they satisfy the requirements of the statute? All these kinds of things are going to be evaluations that you're going to want to know and discuss and be prepared to attack, because it's a fist fight. Like by the time you get in there and you're talking about the two most important things in your life, right? Your children, if you have any, and then everything you've worked your entire life, or at least for the previous years, to build up. And now somebody's wanting to take both of those away from you. And so you have to be prepared, you and your counsel, to walk in there and go to war. I mean, freaking, like throw some punches, haymakers even. And the only way you're going to be prepared to do that is really understanding what's in that evidence. And I would tell you that if you
have a custody evaluation that's negative towards you, you better have a backup plan and have somebody to refute that evidence, whether it's an army of fact witnesses or another custody evaluator comes and gives a differing opinion. But you better throw something into the mix that is going to call into question that custody evaluation, because the courts, put a lot of stock in a neutral custody evaluator, and that is a good way to, set a whole bunch of trial retainer money on fire if you don't have that, if you're not able to attack that custody evaluation, whether the custody evaluator didn't do their homework, or whether they just came to a wrong conclusion, or whether they didn't take into account certain things you wanted them to discuss. I mean, I've heard it all over the years. So you've got to figure out a way. If it's not in your favor, you have got to figure out a way to get that disregarded, whether you attack the expert witness, whether because if you don't, and the judge has an easy decision to just rely on the custody evaluator, because, hey, heck, the custody evaluator went out to the house. The custody evaluator talked to the kids. The custody evaluator talked to both parties. So why shouldn't I rely on the custody evaluator?
Yeah, I mean, that's when you're going to spend your time really kind of, putting quills in your arrow, right? I mean, putting arrows in your quill box so that you can pull your bow back and shoot people. And what I mean by that is, as an example, a lot of times child custody evaluations will happen very early on or midstream in a case. It could be months, if not sometimes years, after that initial child custody evaluation report is prepared before you actually see the courtroom, the light of day. And so what's transpired since then? And so your story really has to focus in. If you have a negative report point, Bryan, you have to focus your story on explaining why the hell that's bullshit.
Yes.
Why the hell you looked at it and you said, that's just a pile of crap, Judge. You don't want to pay attention to it. She didn't do her due diligence, or he didn't write the report correctly.
Or they haven't been to my house.
Even if he did, so much crap.
Exactly. They haven't been to my house in 6 months.
Since then. Shit.
I mean, the custody evaluator hasn't been to my house in 6 damn months. So what do you expect? My house is completely different. I live in a different place now. There's totally different people in my life because she kicked me out of the house. Judge, you shouldn't believe this custody evaluator because and that happens a lot. You get a custody evaluation early on in the case and they think it's open and shut. Then you go to trial a year later and nobody bothers to call the custody evaluator and say, hey, you need to update this report because a lot of crap's changed. We need, kids go to different schools. They have different, somebody lives in a different place. They have different opinions, all kinds of things can happen. And so you need to make sure that custody evaluation is up to date. And to be honest with you, if that custody evaluation comes back negative, the best way that I've ever seen to try to attack it is to get another custody evaluator to do basically a rebuttal report on it and highlight your good sides. Because at least you throw that into evidence and you throw the jello around and something's going to stick against the wall that's in your favor. Because you're fighting a bad custody evaluation is a total uphill fight.
Yeah, it's a gang fight at that point, man. You want to bring your own freaking buddies. You want to bring your own baseball bat to beat people.
Exactly.
And so if you have to bring your own freaking sharpshooter in to try to take them out, then you definitely want to do that. But these are all strategy things that you better have in your game plan well in advance of, hey, you know what? It's the week before trial, and should we think about this?
Too late.
If you haven't had those conversations months in advance, you're screwed. You're screwed. So let's talk a little bit of strategy about, okay, so yeah, obviously child custody evaluations are also think as, when we talk about a theme for your story, right? It's the central theme behind your case, and every attorney should have one, and every client should keep that in mind as they're answering questions as to go into the trial room. You should always spend a tremendous amount of quality time, and that's expensive. Trials are freaking expensive. Spend quality time with your attorney, having them prepare you so that you can answer correct questions on direct and questions on cross, because they're different. Right?
Sam and I tried a case a number of years back, and our client, we felt our client was prepared for trial. We went over testimony with him for at least 5 hours to prepare for trial, and it turned on one, not even words that he spoke at a trial, but he kind of did a thing where he threw an exhibit back at an opposing counsel, and it looked like he had an anger problem, and
which was the central theme of their damn story.
And that killed us. I mean, that was so how you act in the trial, the way that you come across, because they're going to be attacking you. The opposing counsel's job is to make you look like an asshole, and they're going to do everything that they possibly can to make that happen. So you have to stay calm, you have to stay disciplined, and you have to answer the questions in the way that is most advantageous to you, and work with your attorney, because it is when all of your stuff and your children and your most valuable things in your life are on the table, it is very, very difficult to stay calm. And the opposing counsel is going to do everything they can, like I said, to make you look like an asshole.
My grandfather used to always tell me, the work you put in is the result that you get out. And I'm going to tell you right now, that absolutely holds true at trial. Because you may think you're the baddest motherfucker in the planet, right? You sit down and freaking bullets come out your ass. But I'm going to tell you, when you get into that stand and a judge is staring down at you and a well-trained opposing counsel is, peppering you with questions that are just pissing you off, all of a sudden you're getting mad. And when you're mad or you're emotional or you're sad or you're crying, the last thing you do is think straight. And when you can't think straight, I promise you will make a mistake on the stand. And the only way that you can prepare yourself in your case for that not to happen is to practice in advance, spend time and energy, work with your attorney, have them train you on the methodology of what testimony looks like at trial, because it becomes rhythmic, right? There's a lot of strategy behind good trial counsel, and how, when things aren't going your way, it's kind of like a bat. Freaking momentum swinging the other way, or a soccer game, you call freaking timeout. You bring your freaking players to the side just to break momentum. Well, that's going to be objections. That's going to be kind of how you shift, the way you call witnesses, all the sorts of things that you anticipate, try to plan for as you game trial.
I mean, sometimes you have your, I do it, and Sam does it at trial. Sometimes you just object just to break up the rhythm of what's going on the other side. And the other thing you got to be conscious of is, you got to be really, really conscious of listening to the other side sit up on the witness stand and tell lies about you, because you got to sit there with a straight face and listen to other people tell lies about you. And I can tell you that is emotional. I can tell you that is upsetting, and I can tell you that you want everything in your body wants you to stand up and say that's bullshit. That's not true. And but you can't. You have to have a certain level of decorum. You have to listen to them call you every name in the book. You have to listen to things you maybe never even did, and you have to pick your points on when to respond to them.
Well, and when we talk about this process, and why I tell you, like, it's the Reader's Digest version of what you want to say, right? I tell clients that all the time. Because the story that you want to tell is probably Dances with Wolves, right? It's freaking 3.5 hours long.
Out of Africa.
Out of Africa. Or like Gone with the Wind, it's on 2 damn reels. Whatever it is, it's a long story. But what you actually get to do is the cartoon version of that. And so if you've ever seen the cartoon version of Gone with the Wind, if there was a damn version of that, I'm just going to tell you, it's real fast. They're going to zip through crap, and they're just kind of make like, these little side statements about things that you wish you could explain a whole bunch, but you don't have time because the judge is sitting there looking at you in the face saying your trial has this square amount of time, whether it be half a day, a full day, a week, it's not going to be enough. It's not going to be enough.
So let's talk let's talk real for a second. If you were sitting in front of a judge who only hears family law cases day in and day out for 52 weeks a year, and, here's the same kind of stories coming in front of them every day, every day that they go to work, how much of an attention span for your particular case do you think a judge is going to have? So you have to hit the high Reader's Digest points absolutely crucially in your presentation of the trial, and in a quick and an efficient manner.
Right. Absolutely, Bryan. And in that's why it's so hypercritically important that you have a trial outline, that you and your attorney have walked through and prepared a trial outline so that you know these high spots, because you may get distracted. You may go down rabbit holes, but your attorney and you both have to be able to look at a document and say, did we get what we wanted to say across to the judge? Because I'll give you a perfect example of a colossal mistake in relation to children. So we did a trial. We go in, clients are sitting there, they get up there and they talk about how wonderful they are, how crappy the other person is, how it would be a colossal error if the judge were ever to look at that other person and say, they're not terrible. There were problems on both sides of the fence. We had drugs, we had violence, we had all kinds of issues, but they didn't prepare any type of alternative other than their story, right? So
sounds
they
like
said,
a normal Saturday night at my house.
Right? It's option A. It's option A or nothing else. Well, what that does is it pins the judge into a box. They didn't give the judge any opportunity to go in a different direction. And so what you do then, if you don't give judges options, pre-planned options for them to think about, then guess what? They get creative.
Yep.
And I promise you, a creative judge is never going to give you a result typically at trial that you're going to like.
Nope. And so you better have a plan for what's going to be thrown at you, whether it's all lies or not.
Yeah, how to address it, how to rebut it, how, if you don't see it my way, judge, maybe there's a middle ground. Consider this before you go to the alternative, which is their version. I mean, there's just 100 different things that you really need to plan for and to be able to address, especially when you talk about children, because the other piece of trial that I'm going to tell you about, let's just talk about witness prep a little bit. By God, if your lawyer's like, hey, give me your witness list, give me your 15 I love you people, they're going to get up there and you call, hey, you know what, my poker club on Saturday night, they're the coolest freaking bros you've ever seen. And so I know they'll get up there and say, she's a hoe, bros before hoes, they're going to totally back me up. You call them up and all of a sudden the other side's like, hey, haven't you been convicted of domestic violence? Oh, by the way, don't you have 2 DWIs? Oh, you know what I'm saying? Like, if you don't know who the hell you're putting up there to support, you've just tanked yourself. Yes. You've just given the other side. Yeah, you've given the other side all the ammunition they need to just put their foot on your neck.
You want to look like
what's going on.
You want to look like you sit on the first row of the First Baptist Church on the first Sunday of every month. That's the way you want to look when you're walking into that courtroom. And you want people up there that are going to look. As much as everybody loves their mama's always going to say something good about their kid. Nobody loves you like your mama does, right? But
hell, I think Dahmer's mama loved him, didn't
he? Exactly. So my point is that judges discount mama's testimony because they know mama's biased and they know mama loves her kid. No question.
What about your best friend, though, Bryan? I'm sure your best friend, they're going to believe that person.
Well, not necessarily. They're going to discount it. They're going to put some discounting on it. They might believe some things, but they're going to put a heavy discount on it. So you want people that, have been around the subjects that don't necessarily have a dog in the fight. Those are going to be good witnesses, teachers that see you with the kids,
doctors, dentists, counselors, coaches, all these people that see you interact as a parent that get to offer evidence to the court that don't care who wins. They just really look at the kid and go, hey, this is the encounter that I had and that I saw, and that's what you should believe, Judge.
That's real. That's how it works because, I love you witnesses are great and pictures of the family, at the mall or looking at Christmas lights or on the Hawaiian cruise are super great and they help and they present a pretty picture. But it sometimes turns on little things. These trials are about proving, why you're better. You don't just have to say that the other person is bad. You have to show why you're better. And that's sometimes a hard thing to do.
Well, and half the time that strategy too, right, Bryan? Because sometimes you just want to go in and you want to pound sand about how crappy that other parent is. You want to highlight that reel and then give a little bit of, but look how good I am. Other times you want to go in because let's say you have two good parents. Two good parents love their kids, hate each other, right? At one point in time, they were the cat's meow, they are Oreo cookies. But now, hell no, man, they're split apart. They don't like each other. They hate each other. They don't want to see anybody win. How do you do that? Well, then you have to be prepared for two good parents to be able to walk into the courtroom and fight about conservatorship. It's going to be in the nuances of the story. It's going to be in the details, and it's going to be those neutral and independent third parties that are going to come in and make the difference. And so you have to have a strategy with your attorney about how to make that happen, how to be prepared, and how to win.
Okay, so that's pretty good. That's a pretty good keeping it real on the trial. Let's talk a little bit about the property. So first and foremost, the first thing that you and your attorney need to discuss and you need to walk in there with is a proposed property division that aligns very closely with what the values that you put in your sworn inventory and appraisement that you have to file with the court. So you're going to have this proposed property division. You need to go in there, and then you're going to have to explain why you ought to have that proposed property division. And in some instances, you're going to have expert witnesses that come in there and say, no, this account belongs to mom because she inherited it from her great grandmother, and this is how I know, and this is where it comes from. So there's all kinds of nuance in the property part of the trial, and if you don't get that right, it can be a very expensive day for you.
Oh, absolutely. Heck, a lot of times people don't even invest a lot of energy in getting the values correct before they walk into the courtroom, right? Because a lot of things where it'll break down is you'll say, hey, you know what? Let's say mama owns a business. She opened a salon when y'all first got married. And now, you're out a professional, but she's got her little business on the side with all these clients. And she's saying, look, it's not worth $5. And you're like, you've got 300 clients, 6 locations. I think it's worth a little bit more than $500. Right? If you don't find some substantial proof and evidence to validate what you're coming in and saying something's worth,
you might be getting $2.50.
That's exactly right, because that puts the judge in an incredibly difficult position, because what judges can't do, or typically won't do, I'm not going to say they can't do because they have done it, but is they can't create things out of nothing. I don't know how many times you'll hear judges with rookie attorneys or poor attorneys, and they say, well, you didn't give me the evidence sufficient for me to be able to make a proper determination on that. And so based on what I have and the limited information or evidence that was presented, here's what I'm going to do. This is the value. And you're like, well, it's way worth more than that, but you didn't present any evidence in there. You didn't prepare anything to come in and justify your position. When you talk about property trials, you're talking about all that discovery, all those statements, all those valuations, all those depositions, all that forensic accountant person that came in, or CPAs, or, business valuators or appraisers. All this is when the rubber hits the road in relation to what it's going to be worth and what you're going to get coming out of the other end of that trial.
And you have to make sure that it's as accurate as possible, and you have a range, because look, if a judge doesn't know how to divide something, you don't want a judge guessing. You want a judge to get to line with your numbers as much as possible. And I'll tell you a big time mistake that happens a lot is you don't value your separate property. Well, if your separate property is not valued accurately and the proper evidence is not put into place, and that means to get separate property excluded from the property division, you have to prove it by not only documents but also testimony. And that is typically a forensic expert, typically an accountant or a tracing expert of some kind, and there are a lot of good ones out there. But and there are a lot of theories on tracing, so you have to have a reliable expert. And because here's the deal, if you have $1 million in separate property and only $500,000 in community property, you don't want to be dividing $1.5 million. You want to be dividing 5, because you want to keep your million on your side of the ledger. And if you're able to do that. If you don't, then you're up shit creek without a paddle.
Yeah, you better start paddling really quick. And the thing about that too, Brian, is obviously, when we talk about situations that people walk into property trials and the work and the expense of having to prepare for this was when all that money and those man hours will be valuable beyond worth, beyond measure. They'll be worth their weight in platinum because these are the pieces of the puzzle that afford the judge the opportunity to really see and relate to the story that you're telling. Because it doesn't matter if you've got the best story in the world. When it comes to property, if you don't have the facts to back it up, you're not going to win. It has to be a healthy balance. You have to have substantial facts to support and validate your position along with this story. And it's got to fit seamlessly. It's got to be part of the narrative that you're presenting to the court in that short, truncated amount of time. And in order to be able to do that, you have to be a wordsmith. You have to be a craftsman. You have to be a painter. You cannot be a plumber. And what I mean by that is you can't go out and hire a lawyer who's never been in the courtroom to come in and try to lay some pipe together and go hey, look, if you look at this, I promise it's a Rembrandt. It's not a Rembrandt. You get somebody on the other side who knows how to tell a story and present facts and articulate them all well in a seamless story. You're going to come out the other end in a very positive way.
In large estates, 3% or 2% difference in a property division is a heck of a lot of money. And it's worth probably everything you spend on the trial. Now, in some instances, it's not worth what you spend. But if you have, you're trying to keep $1 million separate, the $15,000 that you spend on a good tracing expert is well worth the money if you can save yourself $1 million.
Well, hell yeah. Not only that, Brian, but you can a lot of times ferret that stuff out before you even start the trial. Right? Because the smart lawyer who looks at that and says, look, I've got a limited amount of time to talk. The last thing I want to do is waste energy on a point that I'm absolutely going to lose on. I'd rather spend time on money and energy on things that we can possibly walk away with. So maybe they'll stipulate to that separate property claim. But this is all stuff that you have to be able to justify, right? The burden is on you if you're going to come in.
And that's where a good trial counsel is going to get that nipped in the bud before the trial ever even starts, or have a separate legal argument before the trial even starts, and may possibly get that stuff excluded. So that's a tricky issue, but it's doable. And that's where, like you said, don't get the paint by numbers guy to come in and try to paint you a Rembrandt. You need an artiste.
Without a doubt. Experience is something you should be talking to your counsel about, and that's okay. Look, there are plenty of attorneys out there. I call them paper lawyers, right? They're great on paper. They're great on settling cases. They're great on everything up to the day that they walk into that trial courtroom because they don't like it. Hell, not all of us like to be in a fist fight. I get it. But that's okay. If you're going to get into a fist fight, by God, you need to have somebody who doesn't mind getting dirty, who doesn't mind fighting for you in that way, and has some experience doing it. Because if they get caught flat-footed and they get knocked out, you get knocked out. They're your proxy fighting for you.
Your gladiator needs to, they're going to give you good advice and tell you when to settle and when not to settle. But, find yourself somebody you can rely on. Find yourself somebody you can trust. And you got to throw caution to the wind sometimes, and let it all. I mean, it's not the time to. You have to be strategic about it. You have to say the negative points about the other person without sounding like you're just mad because you're getting a divorce. It's a very, very difficult, and it's an exercise in discipline. Like I said, you got to point the negative stuff out without there being, it look like you're just he's just so overcome with hate he can't get past it. He doesn't really want custody, or he doesn't really want what he's asking for. He's just mad. You got to get away from that, or she's just mad, or she's just a scorned wife, or whatever it is. Whatever crap they're trying to say, you have to come in a reasoned and methodical way.
Yeah, absolutely. And as we're talking through this, and I would just encourage clients to understand this. No one can tell your story like you tell your story. Right? Even when it comes to the financial picture of it, because a lot of times I think clients will look at it, we represent, mothers or fathers who maybe are the stay-at-home version, not the business version, don't have the business acumen. They offer that testimony.
You are one of the two experts on your life, right? On your life and your marriage.
Exactly. I can't tell you how many times I've heard judges say that. I want to hear from clients because clients should know their life, their estate, their family, their children better than anybody else. You can give me people to help kind of guide or clarify their testimony. By God, they better be able to articulate it. And so if you sit down and you look at your estate, you look at the finances, you look at the property, and you're like, I don't understand a damn bit of it, then you need experts to come in and sit down with you.
You better make sure that you understand before you get to D-Day or the day of the trial. That's what I would say.
Yeah, and the other piece I would tell clients, like I try to make them understand is, it's a very emotionally charged event, right? The only other time I think you'll feel that kind of emotion is perhaps like, maybe the death of a family member or a loved one, is because your body is going to tense up, your muscles are going to tense up, your jaw is going to clench, your heart's going to be thumping in your chest, blood's going to be pumping in your head, it's just going to be throbbing, your mouth is going to get dry when you're on the stand or when you're sitting there listening to people lie about you.
You're always going to wish you said something different.
In this process, it really... Absolutely. So I try to tell clients, look, try to do two things to help your lawyer, okay? Number one, don't be in their ear all the damn trial. You're paying them a lot of money to sit there and listen to the other side, pick apart their arguments, prepare rebuttal or cross-examination. They cannot do that if you're constantly chattering in their ear, okay? Number two is write your crap down. What I mean by that is if you have a question, a concern, a point that you want your counsel to make or reiterate or address, put it on a notepad. Rather than sitting there and passing him notes or being in his ear, allow him or her to focus on that process. You've paid them a lot of money to execute on that day. So don't be the reason that they can't.
Well, I think that kind of wraps us up. Do you have anything you want to add?
Well, the only thing I'd add, Bryan, is obviously I want you guys to stay safe. I want everybody out there to, hopefully find a way, do this as a country, as a state, as a people. But on top of that, when you talk about trial, it really, to me, this whole kind of process evolves and occurs when people really can't figure out that it's better to stay out of trial. Now, as trial attorneys, we love trial. I'll tell you right now, that's where I feel at home. That's where I feel like I was born to be. But by God, I'm doing it for somebody else's life. I'm doing it for somebody else's property. And I promise you that you will never get the kind of result out of trial typically that you could if you will just have cooler heads prevail and come to some type of an agreement before or narrow the issues.
Because nobody gets everything they want at trial.
It's going to be your benefit. Cost. That's very true. So that's all I would tell you about trial. It's expensive emotionally, financially taxing. So, make sure that that's where you want to be, or
I couldn't echo that more.
If that's the case.
I couldn't echo that more. Sometimes you're in a situation where you have to go to trial and there's nothing you can do about it and you got to go. But if you can avoid it, try to, because, especially with young children, because it's always more difficult to get back on the same page with a co-parent after you've had to trash them in the courtroom. All right, well, that wraps us up for today. Whenever we come back, we're going to have some. We're going to probably talk a little bit more about. We'll find some other exciting topics to talk about. We'll probably be talking a little bit more about family law and some estate planning potentially, and we will be having some other guests here in some upcoming episodes. But Sam, what's the best place to get a hold of us?
Well, if you want to hit us up on our website, that's astxlegal.com. If you want to call me directly, you can hit me up on my cell. It's 817-914-5472.
And you can reach me. My cell is 214-724-6106. And you can also reach me via the website. We have a contact information, and we're happy to talk with you about any number of legal issues. We're a family law firm that's designed to help the family, and that includes family, that includes probate, that includes civil, that includes just about anything families can encounter. So with that, I thank you for your time today, Sam, and we will catch you next week. Take care.
All right, stay safe, brother.
Thank you for listening, and we hope you enjoyed the Top Texas Lawyers podcast. If you would like a consultation with either Bryan or Sam, please call 1-888-981-7509 or visit us on the web at astxlegal.com. Once again, that's astxlegal.com. Thank you very much.